There is an institution that affects each of our lives every day. It impacts our families, our safety, our health, our property, and our businesses. It can affect the expansion of our communities, rights in marriage, the education of our children, and the processes by which we vote. It is an institution that reaches into every region, every city, and every county of North Carolina. It is a living, changing institution that most North Carolinians will never visit. But it is a co-equal branch of state government, and this year it is celebrating its 200th anniversary.
This program is made possible by financial support from the North Carolina Supreme Court Historical Society, the North Carolina Bar Foundation, and the North Carolina State Bar Board of Paralegal Certification. Additional financial support from the following:
There is a sound and a phrase that have echoed across Raleigh and North Carolina for 200 years.
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
As the North Carolina Supreme Court enters its third century of service, it has a story worth celebrating. This enduring institution has been a source of stability during difficult times, but it has also embraced change while helping North Carolina grow and mature over 2 centuries. The people who know the Supreme Court best are the men and women who have served on the court. The story of the Supreme Court is their story. We have asked current and past justices, judges, and other legal experts to tell us about this remarkable institution and what it means to the lives of every North Carolinian. In this 200th anniversary year, 2 individuals have served as Chief Justice and as leader of the judiciary, our third branch of government.
Really, the decisions that we're making are about people, and they're about communities and about families and about small business owners and about how we look at how the law applies to the disputes among them. And so it's important, I think, for everybody really to realize that even though we're the highest court, we're always mindful that the decisions that we're making are about people and people's lives.
And I hope each and every North Carolinian can understand that 200 years is a long time, and we have a lot to brag about. We have provided as a state a peaceful way for our citizens to resolve their disputes.
In the magnificent courtroom of the North Carolina Supreme Court, you are literally surrounded by history in the form of portraits of all the men and women who've sat on the North Carolina Supreme Court. In the courtroom, you'll see the Chief Justices, the people who've sat in the center chair. And in the hallway, you'll be watched by all of the Associate Justices over the past 200 years. During its first 200 years, the North Carolina Supreme Court has had 101 justices, and of these, 29 have served as Chief Justice. Today, it is the highest court in North Carolina and sits atop of the judiciary, the third branch of government. In this age of instant communication, jet travel, ribbons of concrete, modern cities of glass and steel, and a state population of more than 10.5 million people, we cannot celebrate this extraordinary institution without knowing what North Carolina looked like in 1819. 2 centuries ago, North Carolina was, by most standards, a frontier. There are no photographs from 1819, but drawings, maps, newspaper accounts, data from the United States Census of 1820, and photographs taken just a generation later provide us with a compelling and accurate description of North Carolina 200 years ago. The entire state, from the coastal plain to the mountains, was cleaved by large rivers, and there were few bridges. Travel was difficult and dangerous. Railroads were a generation away. Under the best of circumstances, people who had to travel, including judges, could cover only 30 to 40 miles a day. United States Census figures reveal that the largest towns in North Carolina were New Bern and Fayetteville, with just over 3,600 residents. Wilmington and Raleigh were home to 2,600 early Tar Heels. Salisbury had a population of 800, and Asheville was barely a village. Native Americans of the Cherokee Nation still lived on ancestral lands in the mountains to the west. In 1819, North Carolina was divided into 62 counties, and not the 100 we have today. Illiteracy was the norm. Funding for public education was still years away. The University of North Carolina at Chapel Hill, the nation's first public institution of higher learning, had 5 buildings, a faculty of less than 10, and 1,500 volumes in the university library. Although North Carolina had great natural resources, it was a state with a few haves and a lot of have-nots. In the East, cotton, tobacco, and pine forest products made a few large landowners and merchants wealthy. In the Piedmont and western part of the state, subsistence farming was the rule. Today, it is difficult to comprehend the data from the United States Census of 1820. North Carolina had just over 600,000 residents, and of this number, more than 200,000 were enslaved men, women, and children. Also remember, in 1819, Tar Heel women had very limited property rights and would not have the right to vote or serve on a jury for another 100 years. It was in this setting that the North Carolina Supreme Court held its first session in January 1819 with John Lewis Taylor as its first Chief Justice. These early public servants in the judiciary would help bind together far-flung regions of North Carolina by providing a body of law and a system for the peaceful resolution of disputes. You have already figured out that there are many ways to convey the history of this court. There is a linear history: who, when, where, who served, when did they serve, and where did the court meet. There is a case law history. That's the history of the law, of the court, and even the history of North Carolina in 370 volumes. And finally, there is a demographic history of the court: race, religion, gender, political affiliation, background. Before the formation of the court in 1819, it is important to understand there were courts and a legal system in North Carolina both before and after the American Revolution. Few people know the early history of the law in North Carolina better than Dean Martin Brinkley of the UNC School of Law.
The courts of North Carolina have evolved in an interesting way. They really began from royal courts that were established under the Lords Proprietors. North Carolina was originally a proprietary jurisdiction owned by 8 Lords Proprietors who had full freedom to establish a government and to allocate land to settlers, and became a crown colony in 1729. Around that point, the Lords Proprietors and then the Crown began to appoint a Chief Justice. And so the office of Chief Justice is actually one of the very oldest offices in the state, along with the governorship. It has existed since colonial times. And there were lawyers who were sent to North Carolina from London to serve as Chief Justice of the state. And they held courts in 3 coastal towns that later became important in the history of the court system. And those towns were Edenton, Newbern, and Wilmington. The actual courts that most people visited were local courts called courts of pleas and quarter sessions. And then there was a court called the Superior Court. The Superior Court is really the oldest court that we still have in existence. It's been there since 1776. The Superior Courts originally were manned with 3 judges appointed by the legislature. And those 3 judges were assigned to ride circuits. They would get on horseback and go out and hold court in what really was then most of the state. The state more or less ended about where Raleigh is now. And the first riding might be around Edenton. So they might have to, if the judge lived in Newbern, you'd have to get on the horse and go up to Edenton and hold court for a while. And another judge would be assigned to Tarboro, perhaps.
As North Carolina's population pushed westward and commerce grew more complicated, the demands on the court system expanded. Superior Court judges got together in courts of conference to discuss problem cases and issues facing the superior courts. These courts of conference, however, did not amount to an appellate process or provide a final decision.
Judge Gaston had been serving in Washington. He knew what was going on nationally and came back and told the North Carolina General Assembly, we really need one of those courts of appeals. We need it to develop our law here in North Carolina in a more deliberate and responsible way. He was so well thought of that his views carried the day, and in 1818, the General Assembly passed a statute creating the Supreme Court of North Carolina. And that is our current Supreme Court. So you really had sort of 3 periods, 1819, 1819, until 1868, when there were always 3 judges. A period between 1868 and the 1930s when you had either 3 or 5 judges, and then the period since when we've had 7 judges the entire time.
During the first 100 years of the North Carolina Supreme Court, there were some major decisions and some major personalities. Former Justice Bill Witchard and Dean Martin Brinkley reflect on one of the best-known early justices.
Roscoe Pound was the longtime dean of the Harvard Law School. He wrote a book in which he named the 10 most influential common law judges in American history. And he picked Chief Justice Thomas Ruffin of this court as one of those jurors. Ruffin was very influential in the development of the commercial law of the state during his time. A lot of it in cases involving the railroads. There were lawyers who went out from North Carolina to other states, and they argued Ruffin's opinions in those courts, and those courts adopted the law of those opinions.
Ruffin is an important figure because of what he did for the law in North Carolina. Most notably, in a case called Railroad versus Davis, he established that there were certain broad parameters within which the state of North Carolina could seize private property under the doctrine of eminent domain and pay for that property, pay fair value, but then use that property to do internal improvements for the state. And so you can imagine this was essential for the development of a railroad system for North Carolina.
Thomas Ruffin, like other leaders and judges of his era, reflected the beliefs of the society around him, especially with regard to slavery and women. Today we recognize his legal skills and his contributions to the law, but we look at his record through the lens of history.
I find value in everybody who has served on this court, even when the positions that they took in their opinions and in their way of life have been not just difficult ones, but completely discriminative ones and oppressive ones. The case of State versus Mann, where there's litigation about a slave owner who assaulted a slave by the name of Lydia. He beat her pretty badly. And there's this whole internal conflict that we can hear Chief Justice Ruffin going through as he's authoring this opinion about the morality around the beating of this slave and his own internal thoughts and feelings about the fact that he himself was a slave owner, and also what the law ought to say about that. And we can feel him and see him grappling with those issues of the time. Well, that kind of grappling and wrestling about those issues is really important because the nation was grappling. Certainly we wouldn't want to be where we were, but we also don't want to discount the importance of that jurisprudence of that time in thinking about how we've gotten to where we are today.
The huge portrait right in the back of the bench that sits over the chair of the Chief Justice, that's Thomas Ruffin. Of course, he was considered to be one of the truly great judges of his time, state or federal. I'm not so sure we even should feel uncomfortable about our history. The history is what it is. As Martin Luther King Jr. said, was that the arc of history bends toward justice. And so what we have seen, and thankfully, is our society becoming, in my view, more and more just, more and more diverse, more and more, I think, moral. We are improving.
The judges of the Superior Court and the justices of the Supreme Court were among the most prominent citizens of North Carolina. Most counties had a courthouse, and courthouses were the physical manifestation of our judicial system, the place where justice was rendered. Courthouses were also a gathering place. When a traveling judge came to town to hold court, it was often the social event of the year. At such times, the courthouse became a place for great oratory and high drama. After its formation 2 centuries ago, the North Carolina Supreme Court met in Raleigh. However, from 1847 to 1862, the Supreme Court held its August session in Morganton for the convenience of Western North Carolina attorneys. In Raleigh, the Supreme Court has changed buildings several times. From 1819 to 1887, our Supreme Court was primarily located in the State Capitol building in the northeast quadrant. From 1888 to 1913, the Supreme Court held proceedings on Edenton Street. For a quarter of a century, our court was located in the building now occupied by the North Carolina Court of Appeals. In 1940, the Supreme Court made its final move to its present location on East Morgan Street. It goes without saying that for most of the early history of the judiciary, it was a man's court. The same was true with legal education in North Carolina. Legal education took a significantly different form from the system of law schools that we now have across North Carolina.
Historically, there was nothing that resembles the modern American law school. Lawyers got into the profession through basically an apprenticeship. You read law was the terminology under a lawyer or a judge. John Lewis Taylor, the first judge of this court, taught prospective lawyers while he was Chief Justice. David Swain, later governor of the state and longtime president of the university, for example, read law under Chief Justice John Lewis Taylor, spent a year in Raleigh doing that. That was the norm in the early days of the state and the country.
A number of judges and well-known lawyers took in students, but none on the scale of the law teaching enterprise of Justice Richmond Mumford Pearson. His law school in faraway Yadkin County was known as Richmond Hill. At Richmond Hill, Pearson was responsible for the education of several hundred lawyers between 1848 and 1878. Another well-known judge at the time, William Horn Battle, taught law at Chapel Hill beginning in 1845, giving UNC the first university law program in the state.
Here in North Carolina, the critical figure in the transformation of this law school, and really of all the other law schools in the state, to the newer method of legal education was not a lawyer at all. It was Harry Woodburn Chase, the president of the University of North Carolina from basically in the decade of the 1920s. But one of the things that he did was to say to the trustees that he wanted the law school at UNC to become a modern law school on the Harvard model.
UNC was not the only university school of law, because in 1868, Trinity Law School opened its doors and later became Duke University School of Law, which was followed by Wake Forest School of Law in 1894. Today, there are 3 other excellent accredited law schools in our state: North Carolina Central School of Law in Durham, Campbell University School of Law in Raleigh, and Elon University School of Law in Greensboro. With the new system of legal education and dramatic change in this state from an agrarian to a manufacturing economy, tobacco, furniture, and textiles, the Supreme Court expanded to 7 members in the 1930s. The demands on the Supreme Court increased, and soon a new appellate court was needed. The Chief Judge of the North Carolina Court of Appeals, Linda McGee, tells the story of North Carolina's newest appellate court.
Well, around 1955, it was clear that the Supreme Court's workload was increasing, mainly because of the fact that North Carolina was growing. So there were different kinds of courts in place at that point in time. We had things like mayor courts and justices of the peace. We had, just a variety of different kinds of courts and the trial courts. And the feeling was that we needed to have something that was centralized. Well, the Bell Commission studied the issues for several years. Then they made recommendations to the General Assembly, and eventually there was a constitutional amendment that was proposed. The constitutional amendment took some period of time for there to be discussion, but it passed, and it passed by a large measure. After that point in time, as one of the parts of the Bell Commission's decision was that there would be a court of appeals, an intermediate court, a court that could basically take some of the workload from the Supreme Court. In North Carolina, you have an appeal of right to the North Carolina Court of Appeals. No matter why you decided you don't like the decision of the trial court, you had the automatic right to bring the matter to the appellate courts. The Court of Appeals, we sit in panels of 3 here at the court. If we have a unanimous decision, then there is not any kind of opportunity automatically to go to the Supreme Court normally. However, if there is a dissent, if somebody disagrees, then the person who has basically lost in the Court of Appeals has the right to appeal to the Supreme Court. That's an automatic, guaranteed right for them to have that opportunity. The cases involving the business court, also cases, of course, involving the most serious issue of anyone in our state, the death penalty cases, they all go to the Supreme Court.
Many North Carolinians are still unaware that our state Supreme Court is at the top of the North Carolina judiciary, the third co-equal branch of North Carolina state government. Even with an intermediate level for appeals, the North Carolina Court of Appeals, the Supreme Court always has the last word in matters involving state law. Chief Justice Burley Mitchell and Chief Judge Linda McGee explained.
The Supreme Court, of course, is what they call the final arbiter, the final decision maker. I always said it's not that we're infallible, but we are final. So, and then the court's decisions on questions of law, as opposed to questions of fact, which are peculiar to the case, becomes part of the body of the law. And under our doctrine of stare decisis, which is binding case law, it's binding on all the other courts in the state. Interestingly, on questions of state law, even the federal courts have to follow what we said, what the state Supreme Court said.
One of the difficulties that we have as judges and justices of the Supreme Court, keeping in mind the fact that we may not be delighted with an opinion that we have to write, because there may be precedent in place that simply keeps us from being able to do what we might feel is more right. Sometimes it's very difficult to do those decisions. We may not be necessarily proud of them, but we are bound by some of the things that have come before us, and we do have limitations.
Perhaps the most frequently asked questions in increasingly partisan times is, do politics and party labels have a place in the decisions of our Supreme Court or in lower courts?
You know, there's a difference between somebody having a point of view and somebody being political. Now, there's some issues on which there is a political divide, but on the court, there is not a political divide. And I never, while I was on the court, felt that, although I was the only Republican at the time, actually the first Republican since Reconstruction, I never got the feeling that the court, the members of the court, were treating me differently or looking at me differently because they knew I was Republican, and I certainly didn't feel that way toward them because they were all Democrats. I knew that they were Democrats. Never crossed my mind to confuse their politics with their decision in a case.
People need to remember that the justices and judges generally are not servants of the people, but what they are is servants of the law and the Constitution. Other folks write the Constitution, write the laws. The judge's role is overwhelmingly to simply apply it as written.
Our duty is to apply the law, not to apply our own personal preferences. And so at the end of that conference, we've taken a tentative vote, and at the end of the week, we will assign cases for justices to author opinions on behalf of the court. And then we have a process that is very laborious and takes some time to try to get those opinions right. And that's why it's so important to have a multi-member appellate court where you have different life experiences and you really get the benefit of everyone's perspective on getting that opinion right.
I think often the perception about how politics plays a role in the work of the court is just incorrect. The bottom line is probably in about 85 to 90% of our decisions, we are unanimous in those decisions.
In its first 100 years, the North Carolina Supreme Court brought stability and certainty to the legal system and helped a young state to grow. In the 20th century, new faces brought change to the court and North Carolina. One of the most significant North Carolina justices of the 20th century was Walter Clark, whose story is told by former Justice Bill Whichard.
Certainly one of the most interesting members of this court was Chief Justice Walter Clark. Clark served on the court 35 years, 24 of them as Chief Justice. That's the longest tenure of anyone in history to date, and almost certainly will not be exceeded. But he was well ahead of his time in dealing with the law as it related to women and children. He brought women into an equal position before the law in many respects, and he was very concerned with making the law so that it protected children.
One of the most important changes in North Carolina's judiciary is embodied in the story of Susie Sharp, who marched from the courtroom to a Superior Court judgeship, all the way to this state's Supreme Court. Chief Judge Linda McGee of the North Carolina Court of Appeals begins the story of Susie Sharp and other change agents on the courts of North Carolina.
When I was born in 1949, the first woman was appointed judge in North Carolina, and that was Susie Sharp. By the time I was in law school, she was Chief Justice of the North Carolina Supreme Court. I'm proud of the fact that she was able to become, quite frankly, the first woman in the country that was elected as Chief Justice of her state. I think that alone speaks well to encouraging women to have an interest in becoming a judge. She basically was Chief Justice at a time that life was in a bit of a turmoil in the 1960s and 70s. And that was at a time when most women felt, perhaps, that their two primary career opportunities were primarily being a teacher and being a nurse. However, having someone sitting on the Supreme Court as the head of the court system, being a woman, I think encouraged a number of us to seriously consider that's the direction that we might want to do. And I think it affected people outside of North Carolina to try to do the same kind of thing.
The incredible story of Susie Sharp, both on and off the court, was captured by attorney and author Anna Hayes.
She graduated from law school in 1929. In 1930, the percentage of attorneys in the United States who were women was 2.1%, which is a pretty small number. And so in North Carolina, it was much less, almost invisible. And if she had tried to go out and open her own office, a solo practice or whatever, she would have starved. Probably the only way she could have practiced law would have been to go into practice with someone. In this case, it was her father who was an attorney.
Well, it all came about because my father was a lawyer. He was a very busy man, and we rarely saw him except at meals. Mm-hmm. And he would entertain us with stories of his latest exploits in court. And I just thought to be a lawyer would be wonderful.
And she was also very unusual in that she was a trial attorney. and there were almost no women trial attorneys. That was considered something very masculine. The style was bombastic and loud, and it's simply, no one had ever seen a woman trial attorney. And so there she was in 1929 addressing her first jury, gentlemen of the jury, and that's what it meant, gentlemen. Women in North Carolina weren't allowed to serve on a jury for another 17 years until 1946. And so for 17 of the 20 years that she practiced law, she had all male jurors. So it was a very, very small universe of women. The courthouse in those days was considered no place for a lady, not even a spectator. And so she was extremely unusual and in a very tiny minority.
It was big news when Governor Carr Scott surprised state leaders and the legal profession.
In 1949, Governor Carr Scott appointed her to be the first woman judge in North Carolina on the Superior Court. And she was known as a special judge, which is a judge that the governor can appoint, doesn't have to be elected. And special judges hold court all over the state, from the mountains to the coast. And I mean, these were the days where her car might not have even had a heater, let alone air conditioning. There were no 4-lane highways or anything else. These little tiny county seats she would go to hold court. There's probably no hotel that was suitable for a lady. She'd have to stay in somebody's home or maybe 20 miles away at a hotel. Most of the courthouses didn't have a ladies' room. Everybody, all the lawyers dressed up and shaved and combed their hair and came to see her.
The talents of Susie Sharp as a judge did not go unnoticed by Terry Sanford, the charismatic young governor, elected in 1960.
She was on the Superior Court bench from 1949 until 1962, when Terry Sanford appointed her to the North Carolina Supreme Court.
But I came in at a time when we had no Court of Appeals, and the workload was simply terrific. In fact, Judge Denny, the minute he heard I was appointed, he called me to come on down to Raleigh and get to reading records, because if I got behind, I'd never get caught up. Mm-hmm. And I don't think I ever got caught up the years I was on the court.
Well, Susie Sharp was certainly one of the best-known people in North Carolina. I mean, she had traveled the state for 13 years as a judge and been on the Supreme Court since 1962. And then in 1974, she had to run for the position of Chief Justice. And so she had to do some politicking. It was the first time she'd had to do that, really. And she was the first woman in the United States to be elected Chief Justice of a state Supreme Court.
Susie Sharp's celebrity as a fine judge and public servant did not stop in North Carolina. Perhaps, as Anna Hayes explains, Susie Sharp could have been the first woman on the United States Supreme Court.
Governor Terry Sanford really thought he was going to get her on the United States Supreme Court to be the first woman on the United States Supreme Court, because he had been so instrumental in getting Jack Kennedy elected president. And he had some payback coming. Kennedy nominated 2 justices to the U.S. Supreme Court in his first 2 years, but then the third one, Sanford was sure he was going to get her on there, and he wrote to Kennedy and proposed that he nominate her. And then to his horror and shock and surprise, Justice Sharp said, "No, I don't want to go," and turned it down. A pretty sure shot she could have been Sandra Day O'Connor. In 1976, she was on the cover of Time magazine with 11 other women. Instead of having the Man of the Year that year, as Time often did, they had 12 women, including First Lady Betty Ford and Billie Jean King, the tennis star, and a bunch of other people, and Susie Sharp was right up there with them.
Chief Judge Linda McGee introduced us to another justice on the North Carolina Supreme Court, another groundbreaker, Henry Fry.
Other people that I have particularly admired won't surprise anyone. That is Chief Justice Henry Fry. He was the first African American to have the opportunity to be able to serve on the North Carolina Supreme Court, and then he became the first Chief Justice to do so. He had a long history in terms of doing firsts. He showed that Anyone who was interested in being able to serve on the bench and willing to do the hard work to get there had the opportunity, no matter what their race might be, no matter what their color, their ethnicity, whatever their gender might be, they had the opportunity to be able to do so.
Henry Fry had served in the Air Force and had graduated from North Carolina A&T. But in the 1950s, such a background did not remove barriers for a person of color.
August 25th, 1956 was a very important day in my life because that afternoon I was coming to Greensboro in order to marry my sweetheart. And that morning I decided to register because in those days in the small counties, you could only register on a few days before the election, usually on Saturdays. And so I went by to register to vote. And the person started asking me questions about naming founders of the United States Constitution and things of that nature that were not things that you needed to know in order to register to vote. And they call it a literacy test. He said, well, these questions are in the book, and proceeded to continue to ask me a lot of questions that I knew were not appropriate. And the bottom line is that if I quit trying to answer his questions, and he said, well, I'm sorry, you don't pass, so I'm not going to register you. That happened on the morning before I was married that afternoon. And on a lighter note, when I was walking down the aisle, my wife was smiling, I was smiling, walking down, and everything. And I whispered to her, I said, they wouldn't let me register to vote this morning. She looked at me with that pretty smile and said, "We talk about it later."
How did Henry Fry become part of the North Carolina Supreme Court as its first African American justice?
Well, interestingly enough, when I entered the law school in 1956, I was the only African American in my class. There were, if I remember correctly, and I think this is right, I think there was one woman in the class. At the time I was appointed to the court, there had been no African Americans on the Supreme Court of North Carolina, to my knowledge. Things happen because somebody decides that you need to make a change. And I don't mind saying that in my case, as far as the appointments, that Jim Hunt, who was governor, decided that I would be a good person on the court. And he had seen me in the legislature, and he knew that I would try to do the right thing.
Chief Justice Fry explains why differences in experience and background are important in the judiciary.
So I think that on the highest courts, and really on all of the courts, there ought to be that variety of experience of people coming to the court. And it's not just race. Part of it is people who have grown up in poverty rather than people who've grown up rich. All of these experiences help, and I think having variety on there is extremely good.
Trial and appellate attorneys know the value of judges and justices from diverse backgrounds and different schools of thought.
When I look at our Supreme Court in North Carolina today, again, I really feel that that is a culmination of these tiny step-by-step changes that were made across the state in our trial court bench, and we've moved on up to we've really made a huge amount of progress in having our courts look like and represent everybody in North Carolina, no matter from what walk of life they come from, economic background, race, color, religion. We really do have an extraordinarily diverse bench. We can still do better, but I am very proud of where we are today.
I think it's vitally important, not only for me, but also for my clients, that the courts of North Carolina at every level look like the people of North Carolina. because it's about trust and faith in the judiciary, that your case will be heard fairly, that the arguments that are being made will not fall on deaf ears, and that if the court looks like the people of North Carolina, it gives the people more faith and trust that their case will be decided fairly, that perhaps it's going to be heard by someone and interpreted by someone who has been in a similar situation before. So I think it's vitally important that the courts of North Carolina actually reflect the people of North Carolina.
I think that before the arrival of Susie Sharp and maybe Henry Fry, the court, it was always a court of which we could be proud. North Carolina people are proud of their courts, and they're very proud of their Supreme Court. But to me, the way I look at it now, looking back, the Supreme Court of North Carolina had never really been to the mountaintop until Susie Sharp came and until African-American judges came like Henry Fry. And it did have the feeling that it kicked this court into a different gear, and a higher gear, and a faster gear. And it made people feel comfortable.
Chief Judge McGee told us about another change agent on the North Carolina Supreme Court, Patricia Timmons Goodson.
Then I also had the pleasure of serving with Pat Timmons Goodson, and she was the first African-American woman to serve on the North Carolina Court of Appeals. She and I, for a few years, were the only women on our court. And then she had the opportunity to go to the Supreme Court. And Justice Timmons Goodson has continued to serve the country, and she serves now on the United States Commission on Civil Rights.
I think that the presence of Henry Fry, Susie Sharp, Sarah Parker, Rhoda Billings on the court shaped the way that North Carolinians looked at our court. I think that myths and stereotypes were dispelled, but individuals could literally look at their court, look at North Carolina's court of last resort, and could see themselves or one of their own, perhaps a daughter, perhaps a son. It just, I think it takes the weight off of the shoulders of others when they realize that this has been done before and by someone that looks like me. I think I can do it. I think I can do it too. And that's what those figures represented for me, and I think for a lot of North Carolinians.
Like every justice who serves on the Supreme Court, Patricia Timmons Goodson found that the court had a significant impact on her life.
My time on the court required me to work harder and dig deeper inside than I ever had before. And that was because I was mindful of the magnitude of the decisions and issues that were coming before the court. I understood that we were often setting a precedent that would remain in place for decades. I was also mindful of the fact that few North Carolinians had ever had the privilege of serving on the court.
Justice Timmons Goodson reminds us that before the stories of changemakers, Susie Sharp, Rhoda Billings, Sarah Parker, and Linda McGee, there had to be a first woman licensed to practice law and people to advance her cause.
Albion Tourget. He was the lawyer for Tabitha Holden, the first woman admitted to the state bar of North Carolina. It's my understanding that she showed up with her younger brother to take the North Carolina bar exam. At that time, the bar was administered by the Supreme Court of North Carolina. And so they told her to leave and to return the next day with a lawyer. She returned with Albion Tourget, who successfully argued to the Supreme Court of North Carolina that his client should be permitted to use the brain that God had given her. And they agreed with it. She took the exam and passed it and was the first woman admitted to the state bar in North Carolina.
In interviewing judges and justices, we found that the Supreme Court can often change the men and women who serve on it. One of the most powerful stories of the court's effect on a sitting justice and on justice in North Carolina was told to us by former Chief Justice Beverly Lake.
We have, in my opinion, the greatest judicial system in the world, but it is not perfect. It is subject to mistakes. So we had made some mistakes, not many, very, very few. After a certain amount of nagging by one of my very valuable research assistants, my clerks. Her name was Christine Muma. She convinced me that there were people in prison that we had convicted wrongfully. So at that point I formed, and that was in November of 2002, I formed the Actual Innocence Commission, and that was a 8-member commission consisting of judges at all ranks, all levels. We were actually trying to bring about justice across the board for everybody, including people who had been convicted after going through a trial and the jury had found them guilty, but we found that they were wrongfully convicted.
The success of the North Carolina Innocence Inquiry Commission, started by a North Carolina Supreme Court justice, did not stay in North Carolina.
I'm very, very proud to say that North Carolina was the lead state in this program that took place across the country. It is so wonderful to see that emotion on the faces of those people who are finally free.
With new faces and backgrounds on our Supreme Court in the second half of the 20th century, the court now looks like the people of North Carolina. This change is important to all the women and men who have served on the court and who will serve on the court in the future.
In my opinion, it has benefited the people of North Carolina because, first and foremost, the court belongs to the people. The judges are trustees of the court, but to serve the people. And all lawsuits, irrespective of whether it's an individual against an individual or a corporation against a corporation, involve people. It's important that the courts look like the population. And I think in that regard, the changes we have had in diversity in terms of gender and also in terms of racial makeup have been very important and crucial to the citizens of North Carolina.
And so the court affects the lives of everyday people as well as those who are in corporations and things of that nature. And so it behooves the people of North Carolina to try to elect people who are not all, I'll just say, not all graduates of one school. I'll just leave it at that.
Today, 200 years after its formation, the North Carolina Supreme Court is much more than a courtroom and a great law library. The Chief Justice and the court sit at the top of a unified court system.
Well, as Chief Justice, I do sort of wear two hats. I am the leader of the Supreme Court, and what that essentially means is that I hear the cases just like the other justices do. I have the same levity and vote, if you will, in terms of making those decisions. And then in addition to that, I am also the leader of the judicial branch. And as a part of the branch, we have over 6,000 wonderful folks who are elected judges and elected district attorneys and clerks of court and magistrates and a host of other folks who are working very hard to make sure that our justice system is working the way it's supposed to.
There is no better time than during the celebration of this court's 200th anniversary to see the North Carolina Supreme Court in action.
You know, one of the exciting things about celebrating the 200th anniversary is that the legislature has given us the authority for a 3-year period to travel the state to hold court. And so we have been to mountain communities, Morganton and Hendersonville and Asheville, Halifax and New Bern and Greenville. And so it's just been a wonderful way to be able to have access to communities in a way that we never would have been able to before.
This important, durable institution has changed for the better as this state has grown in many ways. Get to know your North Carolina Supreme Court and celebrate it.
God save the state and this honorable court.
This program is made possible by financial support from the North Carolina Supreme Court Historical Society, the North Carolina Bar Foundation, and the North Carolina State Bar Board of Paralegal Certification. Additional financial support from the following: